Okay, I'd like to call the Public Airport District to order. Start with the pledge. Pledge allegiance
To the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Clerk, will you call the roll, please?
Brown?
Here.
Director Guy?
Here.
Director Clayton?
Here.
Director Rodriguez?
Here.
Okay, let's start off the minutes of the regular meeting held January 22nd, 2026.
I read the minutes and I make a motion, we adopt them.
You have a first.
Wasn't here, but I did watch it online.
Yeah, I think
Okay, so I'll second the motion.
Okay, we have a first and second. Any questions? All those in favor? Opposed? Here we go on to committee reports.
President, your on the 2nd of February, your real estate committee met. On the 4th, your executive committee met to set the agenda for this meeting. On the 9th, your finance committee met. On the 9th, your real estate committee met, and on the 11th, your finance committee met again.
Any questions for that? Okay, we'll go on to general manager's report.
Real quick, furtherance of GA Customs, Director Adams and I will be in San Diego at the NBAA International Operators Conference on the, I believe it's March 1st to the 3rd. Regarding solar, we're still working with PG&E. Our contractor at least is working with PG&E to make the final connections. I don't have any final answer there. And I just wanted to share with you on the 28th of January, the city manager pulled together a group of folks, chamber, from other groups, to discuss the future of tourism in Santa Maria. So the city manager and city staff are really interested in working with everyone to further tourism, which I think is a good thing for all of us.
Sure, yeah, good deal. The international operators license, what's that about?
Since the conference, it is, NBAA has a group of international operators that operate commercial general aviation aircraft internationally. So who else to talk to other than schedulers and dispatchers, and that's later in the month.
Potential customers.
Let them know that we are on the verge of having customers.
We'll go on to the finance report.
Yeah, so for you today is the demand register for checks issued from January 28th to February 9th. And if you have any questions, yeah.
We've now been in this position 2 times. That's your second time sitting here. If you needed to get your arms around everything,
Yeah,
how you feel on the percentage wise of putting your arms around everything?
feeling pretty good. I think I'll be able to give you more of an in-depth financial kind of outlook at our next meeting. That way, we can have actual goal in place by then and some policies brought forth to the board. But yeah, it's going really well.
Cause we want to decrease the debt that we're doing here and trying to increase our money so that we can stabilize ourselves and keep moving on.
Absolutely.
And you're looking at ways to make that happen.
Absolutely. Yes. Yeah. And yeah, so one of those future agenda items is kind of setting the foundation for something like that.
So you're on top of it.
Yes.
Thank you.
Oh, yeah, absolutely. But is there any questions as far as the demand register? Any questions on payables?
We should give it first and seconds before questions.
Well, it's again, just saying. Did anything seem to jump out as being something you would have said, what's this?
Not particularly, not yet. I have scrutinized all of these payables since I've been here. So it's been a little bit easier to kind of get an idea of what we pay on a monthly basis now that I've been here almost a month. So as of right now, nothing is kind of sticking out. And then, yeah, really, there hasn't been anything that's kind of caught my attention or our auditor's attention. So as of right now, we're looking pretty good as far as payables go. Like I said, we'll have a better financial outlook for presented to you at future board meeting.
In all fairness to him too, we did have the financial committee meeting and he answered a lot of questions. So he's definitely on the pulse.
Yay.
Yeah.
Thank you very much. We need
He's
that.
getting a handle on it.
Yeah.
We need to get a dose of reality, and so what we need to do.
Absolutely.
So looking for a motion.
I move that we accept the demand register as shown in the packet this evening.
I'll second it.
Okay, we got a first and a second. Any questions that haven't already been asked? All those in favor? Opposed? Okay. We'll move on to public session. Statements from the floor will be heard during public session. Request to speak forms are provided for those wishing to address the board. After completing the forms, please give it to the clerk. Requests requiring board action will be referred to staff and brought to the next appropriate agenda. Members of the public are cordially invited to speak on agenda items as they occur. Staff reports covering agenda items are available for review in the office of the general manager on the Tuesday prior to each meeting. The board will establish a time limit for receipt of testimony. The board reserves the right to establish further time limits for the receipt of testimony. No request. Okay, we'll go on to resolution 953, a resolution of the Board of Directors of the Santa Maria Public Airport District expressing appreciation to Ignacio Nash Moreno for service on the Board of Directors of the Santa Maria Public Airport District.
Whereas the members of the board of directors of the Santa Maria Public District take this opportunity to express their genuine and sincere appreciation to Ignacio Nash Moreno for his valued long-standing contribution and outstanding service performed as president of the board of directors of the Santa Maria Public Airport District. And whereas beginning December 8, 2022, Mr. Moreno has served nearly 3 years on the board of directors and has committed to the needs of airport tenants, the aviation community, and the Santa Maria Valley community at large, and has contributed greatly to the growth and development of the Santa Maria Public Airport. Whereas Mr. Moreno's dedication and guidance while serving on the administration and financial and marketing and promotions committee has greatly enhanced the public perception, appearance, and fiscal well-being of the airport.
And whereas Mr. Moreno's leadership as the liaison for the city and county government has substantially contributed to positive intergovernmental communication, understanding, and cooperation. And whereas during his tenure as president, Mr. Moreno provided critical leadership through the successful settlement of 2 major lawsuits with state and federal agencies, which restored stability to the district and allowed the airport to move forward with confidence. And whereas Mr. Moreno played a critical role in rebuilding and strengthening relationships with local, state, and federal partners, resulting in improved intergovernmental cooperation and renewed trust in the district's operations.
And whereas under Mr. Moreno's leadership, the district advanced key sustainable and infrastructure initiatives, including the addition of new solar infrastructure that reduces long-term energy costs and enhances the airport's financial resilience. And whereas Mr. Moreno championed efforts that successfully secured twice daily commercial air service to a major hub, improving regional connectivity and bringing significant economic benefit to the Santa Maria Valley. And whereas recognizing the importance of long-term financial stability, Mr. Moreno supported updates to the district fee structure to ensure the continued viability of airport operations, maintenance, and future development.
And whereas the director of the Santa Maria Public Airport District commends Mr. Moreno for his demonstrated leadership, thoughtful scrutiny, and steadfast professionalism, which have set high standards of the government excellence during his service. Now, there being resolved that the Board of Directors of the Santa Maria Public Airport District hereby commends and sincerely thanks Ignacio Nash Moreno for his leadership, exemplary professionalism, dedication, and service to Santa Maria Public Airport District. And pass and adopt, we need, this is a roll call, right?
President Brown,
Yes.
Director Guy,
Yes.
Director Clayton,
Yes.
Director Rodriguez.
Yes.
Good job. Okay, item 7 is presentation by district council to discuss Brown Act policies.
Thank you, President, members of the board. Good evening. Your staff asked me to present a little refresher course for some of you, and also a kind of general education for our new board members. When we have new members join a board, it's always a good time to sort of recalibrate our understanding of stuff like the Brown Act and make sure we're all on the same page in terms of the laws that apply to the district and the board of directors of the district. So I'm going to run through really the basics of the Brown Act, and also let you know that for those of you who have served for a while, the Brown Act has been undergoing a lot of overhaul by the legislature over the last couple of years. Especially this past legislative session with SB 707 was a tremendous update and change to a lot of the requirements of the Brown Act. We think that most of those changes don't necessarily impact the district because there are a lot of population thresholds that determine what entities have to do the really expensive and intensive stuff. We're still trying to get wrap our arms around a bill that was tens of pages long with a lot of different changes. So we'll be advising staff and the board if there are changes to procedures that are necessary. But for the most part, if you hear about SB 707, a lot of public officials are complaining about it because there's going to be a cost of compliance and a lot of additional work for staff. If you hear about those changes, you should just note that for this district being small, most of them don't apply to this district. So next slide, please. Open government is a really important part of public life in California. It's so important that the voters put it into the California Constitution a few years ago. So when we seem real formulaic or real formalistic about compliance with these open government laws, it's because it's in the California Constitution. And the voters thought it was important enough to insert it into the Constitution. And it really says that all the public business should be transparent, whether it's the Public Records Act or the Brown Act. The public's got to have a right of access to the work of public agencies. Next slide, please. And the 5 big laws, we're only going to talk about one, but just to refresh the 5 big laws that are kind of the transparency laws in California. The Brown Act is the open meeting public participation law. The Political Reform Act deals with conflicts of interest and political contributions as well as gifts and perks. That's where you file your Form 700 every year. That's under the Political Reform Act. Public Records Act is more staff focused, but it's the public's right to get copies of public documents. The Levine Act applies to political fundraising and creates conflicts of interest when elected officials take campaign contributions and then the contributor comes before you for a decision. And finally, the various due process laws like the Public Contracts Code, where we have to go out to bid for contracts, for example, and we have to have a fair process where everybody is entitled to have a shot at getting government business. So those are kind of the 5 laws. The one I'm focusing on, obviously, is the Brown Act. Next slide. Purpose of the Brown Act, 3 pieces. Public participation, making sure people have the right to come in and talk to you. Making sure that people can be sitting in the audience and have oversight over what your board is doing, and that happens out in the open for the most part. And it has some significant protections for public agencies confidentiality rights. There are certain times, like in a real estate transaction, for example, like in litigation, where the public interest is in having some confidentiality. Because if the other side in a transaction sort of knew everything that you were thinking or instructing your lawyers, they would get an advantage. So there are certain protections for public agencies' confidentiality. For the most part, stuff has to happen out in the open. Next slide. This is what I call the money quote from the Brown Act. It all kind of boils down to this: all meetings of the legislative body of a local agency shall be open and public. All persons shall be permitted to attend any meeting of the legislative body of a local agency, except as otherwise provided. So when you break it down, we think about what's a meeting. We think about what's the legislative body of a local agency. What does it mean to be open and public? What are the rules for public participation, and what are the exceptions? Those are the pieces of that one statute. And when we talk about, is it agendized? Are we in closed session? Do we have an open session? All of those kind of questions under the Brown Act, or questions about your process that you're used to, it's all coming out of this particular government code section. So legislative body, I'm going to cut to the chase. Your legislative body, that's the governing body of the agency. It's also committees that are set up by formal action, even if those committees don't have a majority of the board members. If it's set up by formal action and have a formal agenda, they have formal meeting times, those committees can be subject to the Brown Act as well. But the advisory kind of committees, what we call the ad hoc committees that are kind of put together for a certain purpose, go out and gather some facts and come back to report to the board, those aren't covered by the Brown Act. What does it mean to have a meeting? A majority of the members of the body present at the same time and place, including electronically present, to hear, discuss, deliberate, or take action on any item within the subject matter jurisdiction of the body. The last two are the most important, because a lot of people think you can only violate the Brown Act if you vote secretly or vote behind closed doors. That's not true. It's hear, discuss, deliberate, or take action. So it encompasses a lot more stuff than people normally think about. And those discussions, those deliberations have to take place in open meetings if they're within the jurisdiction of this airport board. So y'all can go sit at Starbucks or have lunch and talk about the weather or baseball or what your grandchildren are doing or anything, even something that's happening in the city of Santa Maria, for example, or a countywide issue. That's not within your jurisdiction, those conversations. So those conversations are not covered by the Brown Act. A lot of times we'll have somebody in the community will say, hey, I saw 3 members of the board sitting at the coffee shop. They violated the Brown Act. Well, no, they only violated the Brown Act if the discussion was something about the board's business. And in small communities especially, people are friends. People socialize on these boards, and there are exceptions to the Brown Act rules to recognize that. The biggest way that people, most prevalent way that people can violate the Brown Act are through what we call serial meetings, where y'all might not actually be in the same room, but you're hearing, discussing, deliberating through an intermediary or through technical means like email, like text messages, and you're essentially having a meeting, even though you're not sitting in this room. There's a couple of ways that it potentially happens. One is what we call the hub and spoke, where your general manager, for example, would meet with each one of you individually and say, hey, this item's on the agenda. Really want to get it approved. What questions do you have? What do you think? And the first board member says, yeah, I think I'm good. I'm going to vote for this. Goes to the second board member and says, hey, I just talked to the first board member and he's okay. Are you okay? Go to the third. He's okay. Are you okay? That's building up the votes in private, and that's not okay. That's a hub and spoke serial meeting. What is okay, and specifically called out in the Brown Act, is an individual briefing. So if he wants to meet with each one of you and individually say, just want to let you know what the item is. I'm not asking what your vote is. I'm not trying to lobby you. I'm not telling you what the other people are thinking. I just want to brief you and answer your questions. That's good practice. That saves time at meetings. It helps board members be more informed and get their questions answered. What he can't do is try to build support or take your temperature on issues and then share that with the other members of the body, if that makes sense. The other way it happens is through what we call a chain meeting, which is one of you calls the other and says, here's what I think about this issue. And that person calls and says, hey, the first guy called me and said, here's what he thinks. If you're on board, we got 3 votes. That's kind of an obvious way of avoiding the open meeting requirements, and that's illegal. That's a serial meeting. So we always advise that if you talk to another board member outside of a meeting, out of an abundance of caution, only talk to one. If you're going to have a conversation about some other issue, and you only talk to one person, and that person only talks to you, right? We used to call it Brown Act buddies. A and B, C and D. You could have a conversation, you just can't cross over. Next slide, please. In the digital age, this concept of serial meetings is a lot harder because there are so many easier ways to communicate and inadvertently violate the Brown Act just by doing stuff we all do in our everyday lives now, whether it's sending emails, sending texts, commenting on social media. That's just like talking to your fellow board members. It's just like having a meeting if everybody is on an email chain, for example, or a text group. You have to be really careful about who's included in those messages. So to avoid violating the Brown Act, you should avoid discussing district business with more than one other member if it's not in a public meeting. Always avoid asking for or lobbying another member on an issue outside of a public meeting. And really, and I'm going to talk about this a little more, I think, in the next couple of slides, avoid interacting with other members on social media. I don't know the extent to which any of you are really involved in social media, but a lot of politicians are really involved in social media and really want to comment and really want to post. And that, again, if you're interacting with each other through that medium, is the same thing as having an illegal meeting. And so you really have to avoid that. In electronic communications, whether it's a text or email or social media, you should not communicate your position on a pending matter to everybody else. Sometimes you get that email from a constituent that goes to all 5 members. And please take action on this item. What you can't do in that situation or should not do in that situation is hit that reply all button. If you want to reply to that individual, it's fine to reply individually, one-to-one, but you can't reply in a way that goes back to your fellow board members and communicates your position. So I wish that Microsoft would sell a version of 365 that doesn't have the reply all just for public officials, but they have never taken my idea on that. And that's the most prevalent way I see that public officials, by mistake and unintentionally, violate the Brown Act. It's either through that group text or through a reply all to a big email chain. On social media, just remember, when you're sending it, you're making a comment or you're sending a communication, it's just like deliberating. It's just like you're in here talking to each other in a public meeting, but it's got to happen here and not out in the Ethernet someplace. I think I've talked about this almost enough, but to the extent you use social media, I just want to make sure you're aware of kind of a narrow provision. You should not comment or react, even as far as hitting like or dislike, to any other members of this board's social media posts. I mean, that should just be your rule, because under a recent amendment to the Brown Act, two people can violate the Brown Act now, even if it's not a majority, just by having that interaction. And the law specifically says, if you hit the like button, that's a communication and you violated the Brown Act. Now, if somebody posts and says, here's a picture of my cat, isn't she great? Hit the like button if you're so inclined. But what more often happens is, hey, I'm sponsoring this community event. I'm having a Frisbee golf tournament. Come on down. Each one of you, if that's on social media, cannot even like it or comment on it because that's an interaction that the Brown Act now prohibits. So just making you aware of even more reason to stay off of social media. It is okay to answer questions from the public on social media. If you have your own social media account and somebody says, hey, what's going on at the airport? You can reply to your constituents on social media. You can give them public information. You can ask the public to give you information. What do you think about this issue? It's really the interaction among the five of you that's problematic. Social media is a great way to get information out to your constituents, and it's perfectly appropriate to do that. It's just that interaction between the five of you that you have to be really careful about. Teleconferences, I think everybody is pretty much familiar. I know Director Guy has participated and others have participated in the teleconference world. There's just a couple of things to be aware of if you need to participate in a meeting by Zoom or on the phone. There's kind of three ways now that happens. There used to be only one. The first and most common is where somebody is just out of town, on vacation, on a business trip, can't be here for the meeting, but you really want to participate. As long as you disclose where you are and that's disclosed on the agenda, and you are someplace that's publicly accessible under the theory, I guess, that somebody could show up and participate where you're participating. I have had board members who have said, I'm at a fancy hotel in Hawaii and I'm going to participate because I'm on vacation. And they sat in the lobby in a publicly accessible location on the phone. And that's absolutely complies with the Brown Act. There are two other more modern kind of changes to allow that. One is if you're sick or if you're caring for a sick relative, for example, and you just can't get out. This came out of COVID, obviously. You don't have to make that disclosure, but there's some other rules that I won't bother you with now. But just know that if there's a kind of an emergency medical situation that you need to deal with, and so you can't be here in the boardroom, we can make remote participation happen if you just let staff know a day or so ahead of time. The second kind of newer thing is if there's a declared emergency, again, this came out of COVID when a lot of the state was shut down and they didn't have public meetings in meeting rooms like this one. The legislature allowed for remote participation during a declared emergency that helped with that problem. When they had the fires in Southern California early last year, there were some communities that couldn't have a meeting, but the board members needed to meet for the emergency situation. And so they did it remotely under this exception. So that is possible. It's going to be uncommon. That just covered that. Next slide, please. There's some stuff that looks like a meeting that's not. And y'all have copies of these slides, so I'll let you read them yourself rather than take the time. But just note that all of you can go to community meetings, events, meetings of other groups, Chamber of Commerce, Little League grand opening, homeowners association. You can all attend that, even if 3, 4, 5 of you attend. That's not a violation of the Brown Act as long as it's open to the public or a significant segment of the public. If it's an HOA or a business group, if it's open, you can all attend, as long as you don't go in the corner and hold a little meeting in the corner where nobody can hear what you're talking about and you're talking about airport business, right? You can't use it as a ruse to hold a secret meeting, but everybody gets invited to a variety of events and you don't have to worry about violating the Brown Act just by attending. Conferences is another example of that. At a regular meeting like this one, it happens at the daytime and location set by a resolution or ordinance and board. We post the agenda at least 72 hours in advance, and it tells you, like this does, just a general brief description of items of business that are going to be on that regular meeting. And that's what you can talk about at this meeting. If it's not on the agenda, other than just some real kind of brief exceptions like a report of an event you attended or making a response to somebody who comes up to the podium, if it's not on the agenda, you can't talk about it. That's pretty obvious. We tell people 72 hours in advance, this is what we're going to do at this next meeting. If you want to come down, come on down. You can't sort of sandbag them by having other discussions that didn't show up on that agenda. A different kind of meeting is a special meeting. That there are special rules for that because you only have to give 24 hours notice of that meeting, and you can only do exactly what you tell people you're going to do at that special meeting. There's no kind of public comment on general items. There's no ceremonial stuff. There's no reports. It's just, we're going to have a special meeting to approve this contract. And all we talk about is that contract. Again, telling people what's going to happen. We're doing it off our regular schedule. We're not going to sandbag you into something. These are real basic. The agenda's got to be posted on the agency's website. You all know that that happens. It's got to be publicly accessible. There's also a list that agendas get mailed out to. And the fundamental rule is we can't discuss stuff that's not on the posted agenda. That's an absolute rule for special meetings. There's limited exceptions for regular meetings, like if a member of the public wants to come up and say, hey, who do I talk to about leasing a hangar? The chair could say, talk to Martin or talk to staff. If somebody has a question, how do we get something repaired? You can give a reference to staff. You can answer a brief question. You can't have a big discussion and make a decision on something that's not on the agenda. Sometimes we have a situation where we have to add something to an agenda. The agenda gets posted and something happens in between the time of posting the agenda, that 72-hour period, and the time you actually have your meeting. There's a process by which you all can vote to add something to the agenda, but only if there's a need to take action before your next regular meeting. So on a rare occasion, we'll post an agenda, we'll have everything going, and the public's aware of what you're going to talk about, and somebody says, oh my God, we forgot this lease is expiring, or this contract is expiring, and we need work done sometime before the next month's meeting. Those kinds of issues, there's a way to deal with that, and we can help get through that process. These exceptions I talked about, these are the things you can talk about at a meeting or have a discussion without making a decision. It's a real limited set of categories, but the Brown Act is a little bit flexible to sort of deal with stuff that comes up during a meeting. The public has a right to speak on any item within the subject matter jurisdiction of this body at a regular meeting. So people can make a comment on any item on this agenda, as well as stuff that's not on the agenda, but is within your subject matter jurisdiction. They can't come in here and say the US shouldn't be backing Israel in the Gaza war. The county shouldn't adopt a general plan amendment. Stuff that's not in your jurisdiction, we're not required to allow public comment on. There's a famous case interpreting this that was about the Berkeley City Council and people who wanted to protest the Vietnam War. And hundreds of people would go to the Berkeley City Council and say, I want to protest the Vietnam War. And finally, the Berkeley City Council said, we got to get work done. We can't take this anymore. And they shut down that public comment because it wasn't in their jurisdiction. The court said, yeah, that's what the statute says. If people want to protest the Vietnam War, they have other options the Berkeley City Council doesn't have to listen to it. So that's kind of a common sense result. Public agencies cannot prohibit public criticism of the agency or of the board. If people want to criticize the agency, staff, or the board, they have the right under California law to do that. We can have reasonable regulations of public comment. The president read those just in the previous item. 3 minutes, speak when spoken to, don't, come up to the podium. Those kinds of rules are specifically allowed by statute. And finally, enforcement and consequences. Just so you know, the consequences for violating the Brown Act can be pretty significant. Usually what happens is somebody writes a letter that says, this happened at a meeting, or this happened and should have been at a meeting. They tell you what the violation is. And the law allows for what's called a cure, which if we get a letter like that says this was a violation of the Brown Act, and we realize, yep, that's a problem. We have 30 days to cure it, essentially a do-over. And if we do it in compliance with the Brown Act, we're pretty much off the hook at that point. A lot of times that doesn't really happen because the person making the complaint isn't really describing the action correctly, or what happened didn't really violate the Brown Act. There's a lot of give and take, and then we end up in a lawsuit. Public agencies tend to lose Brown Act lawsuits pretty frequently because judges sort of err on the side of more transparency than an argument about why something may not have been as transparent. And in those cases, when the public agency loses, we pay the attorney's fees for the party who brought the challenge. So you will find that attorneys like me often, are arguing to sort of cure a potential violation rather than fight it out in court, because taking another action is a lot cheaper than spending a couple $100,000 on a lawsuit. So hopefully we'll never have to go through that together. It's not that pleasant because I have been through it, but that's kind of the reality of that process. There also is the possibility for criminal prosecution against board members individually. If you take an action at a meeting, and all those different kinds of meetings, like a serial meeting that I talked about, would qualify here. If you take an action, like you agreed that something is going to happen, and you have the intent to deprive the public of information about that decision, it's possible to get criminal prosecution. Most times, and in fact, there's never been a successful criminal prosecution under the Brown Act because it's very hard to prove intent. But that statute is there, and it's a potential felony, and one that I'm required to tell you about. That's kind of the ultimate sanction and the ultimate reason not to do this. So that's a brief overview. Happy to answer any questions and appreciate the time. Yes, sir.
So I have a question, Greg, regarding the telecommunications portion of it. If there is a meeting and somebody is away and in a public setting, as you said, in they Zoom in or WebEx in, whatever it is, can they vote? And then how do you handle closed session items?
So the closed session item is essentially the same as the open session, except there's no public access allowed. So I have had closed sessions where the member was in a hotel room or something.
Leave the lobby, go to your room.
Yeah.
Okay.
That's the closed session angle of it. And the answer is yes, you can vote if you're participating remotely. It's just every vote has to be taken by roll call. Okay. So there's no everybody agree on this, or if there's no objection, there's none of that kind of informal voting. It all has to be done by roll call.
Okay, thank you very much.
Is that only in emergencies or certain situations, or can we do board meetings? Can we actually do remote on a board meeting, standard meeting?
A quorum has to be present here. So three of you have to be
So
present.
3 are here, then 2 could remote in.
Yeah.
And vote, just be roll call.
Yeah.
Okay.
Yeah, remember that that those two being away, all have to disclose where they are and be in a publicly accessible location that appears on the agenda. So it's
That has to be on the agenda?
the location does. And under that scenario, if there's an illness, the second kind of remote participation I talked about, that location doesn't have to be on the agenda, but there's another process we go through to get there. So, but the typical remote participation, somebody's on a business trip or on vacation or whatever wants to participate, that location has to be posted on the agenda.
Okay, well, one last question then.
Yeah.
Martin and Chuck are going on a trip. It's not during the time of a board meeting, but let's say it was at a time of a board meeting. Can Martin, being the general manager, and Chuck being the director, can they attend the meeting together via Zoom? Or do they have to attend apart, and do they have to be in the public setting together?
If it's that first kind of remote meeting,
Yes.
they can both be together.
Okay.
They don't have to be, but if they're not together, the
They will
board
have-
member's location has to be posted.
Disclosed.
Martin's location doesn't have to be posted.
Okay.
It's the board member that matters.
Okay.
If it's the exception for a medical
Mhm.
care kind of situation, the rule is there can't be another adult in the room. So, because you're supposed to be sick or you're supposed to be caring, right?
Yeah.
So in that situation, no, they can't be together. And Martin can participate remotely whenever he wants. His participation is not covered by the Brown Act. I'm not encouraging it, but just keep it in mind.
Okay.
If you want to.
Okay, thank you, and thank you, Martin, for letting me use that example.
You good?
Yeah.
All right,
Thanks for your attention.
thank you. Okay, we'll move right along to item number 8, which is approval, consent, and agreement to the levy of a contractual assessment of the leasehold interest with United Lions Corporation leasee of the property located at 3455 Skyway Drive, Radisson Hotel, and authorize board president and secretary to execute on behalf of the district.
Thank you, President, members of the board. You pretty much described most of this item, but just to recap, you have a lease that was way before my time, but it's a lease for the Radisson Hotel. That lease was originally in 2011, I believe, and then it was assigned sometime after that. The operator, which is the United Lions Corporation, and is now your tenant at that site. They're proposing to finance some improvements that they're doing as part of a remodel over there through a California state agency, the California Statewide Communities Development Authority, which is a public agency that helps to finance things like energy sustainability, energy efficiency and sustainability types of improvements, which is what I understand that this item is concerning for the hotel. And so they have entered into negotiations with the CSCDA to get that financing in place. CSCDA requires a consent of the landlord for that financing to go forward. You're not making a financial commitment. You're not being sort of the guarantor of the loan or anything like that, but it's a chance for the landlord to say, yes, we're aware of this. Yes, we're consenting to this financing arrangement. And the most important thing is to be able to say to CSCDA, they're not in default of their lease. That's really the reason that this comes before you, is so we have the opportunity for this board to allow the general manager to sign the letter that says they're not in default. This is still in effect. It's not fraud. So that's essentially this item. We're recommending. We have negotiated the form of the agreement that's before you. We've had great cooperation with the lawyer for the tenant. So we're happy with the form. It's been signed and notarized by the tenant. It's ready to go if this board approves.
One question that I have is, so it refers to the Radisson, obviously, so we know that it's going to be a Marriott. So does that matter in the adoption of this agreement?
Not to us.
Okay, doesn't matter to us because ours is with the United Lions Corporation
That's
and
correct.
theirs is with the hotel chain.
Their operator is not, we're not part of their transaction with the operator.
Okay, I just wanted to make sure that it wasn't going to complicate the approval of this item because it says one hotel, but it's actually going to be another hotel.
Yeah, that's
Chain.
that's not anything we need to be concerned with.
So there's no real risk for the airport. It's just mainly more.
There's no financial risk for the airport. You're not guaranteeing this financing or anything like that. And I don't know if there's a representative here. Yeah, there's a representative here if you might want to hear from.
You have any questions? I mean, it's just it's a major overhaul. It was built in '86, as most of you may know. And there was a lot more work and energy efficient stuff that we needed to conduct in there, including behind the walls. So it's not, and obviously being a Marriott, it's in their upper tier brand. So, and with us relocating the bar, the restaurant and everything, bringing it out into the lobby area, it brings a lot more additional revenue into the local area. And
Sounds like you're gutting it.
it is gutting. It's pretty much more than gutting. It's like opening up Pandora's box. As soon as you touch anything, it falls apart. And so we couldn't just put lipstick on it. It had to be completely good. And that's why we went for a Marriott product.
When are they changing the name?
As soon as we've already been approved we have a Marriott Delta license already in place. Soon as we get to the milestones, hopefully our goal was always end of June. So that's the date we've left on point right now
June for what?
to convert end of June.
How much do you think the money will be spent in remodeling this?
35 to 40 million total all in.
Could you just identify yourself?
So I'm Atul Patel. I'm the principal correspondent of the United Lions Corporation. It's family operated. It's been around since 1981. And I personally myself live in Longboat, but we've been in Santa Maria for many years also. There's a lot of family out here.
So the question I have for you is, and this is for the airport as well as you, we used to have access to the tarmac through the hotel.
Yes.
And will there be access through the tarmac through the hotel after you're done with all the remodeling?
Only for authorized people, yes. But that access is there. We've just closed it up because of the renovation for now.
Okay.
It's temporary, but it will remain. But
So if somebody flies in, would that make them authorized? They're parking behind the front?
It'd be like it was before.
Okay.
That's my anticipation. It's only cut off because they needed to get unbadged people around the building in an efficient manner.
for the exterior part, yeah, to get the correct thing.
Thank you.
Thank you very much.
Good luck.
Thank you.
I'll get a motion maybe?
I move that we approve consent and agreement to the levy of the contractual assessment of the leasehold interest of the United Lions Corporation as stated in the agenda item 8.
Pretty formal. For a second?
I'll second.
Okay, we got a first and second. Any other questions? All those in favor? So carries. Okay. Moving on to number 9, authorization for the general manager to add Director Marvin Rodriguez as an authorized signature on the accounts of Pacific Premier Bank and remove Katia H as an authorized agent.
Because I believe Premier Bank is now Columbia Bank. It's the same bank.
Did Columbia Bank send me an authorization thing today that I deleted because I didn't know what it was?
Yes.
They sent me one and I didn't delete it.
I deleted because I thought it was fictitious because I didn't know who they were. So
We're now with Columbia Bank, which is the same bank that we were.
then maybe they need to resend it to me. Okay, Motion?
I move.
Do you not hear anymore?
She's still here, but I am now the authorized signatory on the account, and so she is relinquishing that duty, and then we're also adding Marvin as a.
I'll make the second on it. Okay, so we got a first and a second. All those in favor?
Aye.
Opposed? Nobody. Okay. Okay, we're gonna go into closed session. Let's take about a 3-minute break before we go in. We're gonna go pretty. Okay, 7:42, we're coming out of closed session with no reportable actions. And we'll continue on and go to director comments. And we will go to.
Okay, so we've covered a lot of ground tonight. In particular, I want to say my appreciation for Nash Moreno. I know that we did the resolution number 953, but above and beyond that, I think his involvement with the board, his involvement with the airport, his involvement with the community has been exemplary, especially when you consider when he was voted to the board and was immediately thrust into the position of president and had to balance an unbalanced board, so to speak. I want to point out that a lot of the work that he's done was absolutely monumental for the airport district. And I know I got in here and Marvin's got in here at a good time based upon energy, effort, that Nash Moreno put forward. So I just want to say again how I'm personally grateful, but as a board member, I'm also extremely grateful for the work that Nash did for this board. That's it.
I miss Nash Marino. He should be here, but he moved to a nice, big, beautiful house and he's doing really well for himself. I know that. We started out together here on this board, and then I saw him on the front page of the newspaper swimming with the salamanders back there, putting in all that stuff. And it was amazing. And so he's done a lot, and he was going to take on these different go to these different programs that nobody else wanted to go. So you're it, Nash. You get to go. Thank you. So we already missed you, and it was a lot of fun having you over here. So yes. You will be missed. And switching gears, we have a big, beautiful airport with American Airlines out there, 2 flights a day, free parking. And to prove that, we've got a Frisbee tournament going on this Saturday. Come on out. You can get some tickets if you come on out. And we're spreading the word. We'll have Sunny Country out there. We'll have some hamburgers, hot dogs out there that we'll be cooking. So that's it. And it's really getting the word out to everybody out there. And we'll be on the radio tomorrow saying the same thing. So as many times I can get on the radio and promote it and get the word out, I think we're going to continue to grow. And so I'm pretty sure we're heading in the right direction with all that we've been discussing. We're limited. Thank you, Mr. Flores, for trying to limit our overhead and trying to figure out to get us in reason to where we should be with our finances. So that's it.
Okay.
I'm glad to have a new member over here on this side. Go ahead.
Probably feels like I don't like him. He's got this big gap.
Way over there.
I like this. It kind of got some seclusion. Just appreciation for Nash for recommending me to the board. I really hope to make him proud, and he's got some big shoes to fill. But hope to bring in my experience and skills, and hopefully bring that same kind of leadership here. So,
Welcome.
thank you, Nash.
Okay, I'll go on a little bit about Nash. I was sitting here in this seat when Nash was here, voted in. And I would say it was about 3.5 minutes from the time he voted in, not know anything, be put into the president spot. He did really well. I told him I wouldn't throw him to the wolves, and
And you did?
no, I didn't. I don't think I did. Maybe I did. Well, just by being there. But he did really, really well. You did a great job. So Anyway, I think the airport's heading in the right directions. I think we're taking baby steps, getting things straightened out, and done. I'm trying to get things, all these loose ends finished and get things done for the first time in a long time. So anyway, and with that, I'll take a motion to go home.
Motion to go home, please.
Seconded.
Get motion to go. All in favor?
Aye.
Aye. Let's go home.
Thank you.